Thank you all for joining us for this Rappaport Forum at Harvard Law School. I am Jeannie Gersen. I'm a professor at Harvard Law School, and I'm pleased to be moderating this forum on stare decisis and Roe versus Wade. Harvard Law School is committed to rigorous discussion and generous listening, and the Rappaport Forum honors that commitment by promoting and modeling full, vigorous, and civil discourse on critical and complicated issues facing our community, our nation, and our world. The forum was made possible by a generous gift of the Rappaport Foundation and honors our visionary alumnus, Jerry Rappaport, who has been helping to promote civic discourse at Harvard Law School and beyond for more than 75 years. As you know, the Supreme Court held oral argument yesterday in Dobbs versus Jackson Women's Health Organization, which is about a Mississippi law that bans abortion after 15 weeks of pregnancy. The case will require the Supreme Court to decide whether to overrule its decisions in Roe versus Wade and Planned Parenthood versus Casey. Those precedents recognize a constitutional right to pre-viability abortion. The conversation today includes the questions whether the court should reaffirm Roe and Casey and how the doctrine of stare decisis should shape the decision. Our discussion is with two leading scholars with formidable bodies of work on reproductive rights, Professor Marianne Glendon and Professor Reva Siegel. I will keep introductions of them short in the interest of using the time for the discussion. Professor Glendon is the learned hand professor of law Emerita at Harvard Law School and a former ambassador to the Holy See. She has written prolifically and incisively in the fields of human rights, comparative law, and political theory. Reva Siegel is the Nicholas Katzenbach Professor of Law at Yale Law School, and her broad-ranging work draws on legal history to explore questions of law and inequality and how courts interact with representative government and popular movements in interpreting the Constitution. Both professors have filed amicus briefs in the Dobbs case in the Supreme Court. So we will begin with some comments from Professor Glendon and then from Professor Siegel, followed by about 20 minutes of discussion and ending with some questions from the audience. Please feel free to write your questions in the Q&A box, the function, which I will then be able to see and introduce into the discussion for our panelists. Thank you. Professor Glendon.
Thank you, Jeannie. And hello, Reva. I'm looking forward very much to our discussion. And I must say that I'm very pleased that Harvard Law School has invited a legal historian and a legal comparatist to have this talk today. I'll begin by stating my view on the subject of today's forum. It is that there's nothing in the doctrine of stare decisis that prevents the Supreme Court from overruling Roe and Casey and returning the abortion issue to the states. In fact, the court's abortion decisions with their shifting rationales, standards, and guidelines are an illustration of why the court has often said that stare decisis is at its weakest in cases involving constitutional interpretation. Before going further, however, I should say that my views on that subject are very much influenced by the fact that nearly all the European liberal democracies began adopting new approaches to the abortion question in the 1970s, just as many American states did. Yet none of them, interestingly, have experienced the persistent level of controversy that we have seen in the United States since the Supreme Court took over the issue in 1973. The most plausible reason for that difference, I think, is that regulation of abortion in those countries has been largely left up to the people and their elected representatives, even when constitutional courts have been involved at some stage. By giving citizens themselves more say, the various European laws, and they do vary, have been able to do what the United States has never been able to do, and that is to proceed with a continued discussion of the problem, but at a much lower level. And this is so even though, of course, the European approaches do not satisfy those at the extremes of the pro-life and pro-choice spectrum. And the product has been various types of legislation that in general are characterized by a good deal of care and assistance to the pregnant woman and her family in what is often the worst crisis of her life, as well as protection for unborn life. And as it happens, those laws, most of them are actually quite in line with what majorities of Americans say when they are asked about particular aspects of the abortion question, rather than just, do you approve of Roe versus Wade? The single greatest difference between the judge-made abortion regime in the United States and many of the democratic compromises that have emerged in Europe is that the US cases generally frame the issue as involving women's liberty interests and the state's interest in protecting unborn life. That makes it sound as though all that's involved is a huge, abstract, impersonal state interfering with women's liberty in its most personal and intimate aspects, but it tends to gloss over the fact that makes abortion the most controversial among our public issues, and unique in that it involves the purposeful destruction of an innocent human life. Now, in countries like France and Germany, I'll speak just of the two that I know best, the abortion question is approached as a tragedy for all concerned. A woman who's often in crisis, an innocent human being, and the interests of state and society, which include assisting women and their families in difficult situations, upholding the principle of the dignity of all human life, and especially in Germany, being extremely careful about treating any human life as unworthy to live. I cite those alternative models not to suggest that we should copy them here, but to demonstrate that political compromise is possible, even when moral compromise may never be. As products of a process of democratic deliberation, the European laws also help us to understand why stare decisis is weak when constitutional interpretation is involved. Roe put a halt to those processes, and by so doing, it drove political energies into the only channels reasonably open to them, namely judicial selection and confirmation. And meanwhile, the court has given us a judicially imposed regime that is so extreme that it has made the United States one of a very small group of countries that have the fewest restrictions on abortion throughout all 9 months of pregnancy. That's due to Roe's companion case, Doe, which certainly will have to be addressed by the court in the current case. Doe's definition of health is so broad that it closes off nearly it is so broad that it imposes nearly no restrictions on pregnancy in the last few months. Now, stare decisis, as we'll be discussing today, serves many useful purposes for our legal system. It promotes predictability, it protects settled expectations, but abortion law in the United States is anything but unsettled. The court tries over and over to settle it, but it just doesn't settle. The cases are like puzzle pieces that just won't fit, no matter how hard you pound them. The court's wavering attempts to ground the abortion right in constitutional text, structure, history, or tradition, along with its shifting rationale, standards, and guidelines, have only rendered the cases more and more unworkable over the years. The cases are so marked by divisions among the justices, fractured opinions, and floundering to find plausible justifications that they've left the lower courts and state legislators without reliable guidance. And they've completely failed to fulfill Casey's hope, the Casey plurality's hope, that they would calm the controversy. Accordingly, it seems unlikely that yet another attempt at repair will settle the law or will quell the controversy with all of its harmful effects on the national politics, judicial appointments, and the integrity of the judiciary. To be clear, I would not suggest that returning this deeply contested issue to the states, to the ordinary democratic processes, the messy processes of bargaining, education, persuasion, compromise, and voting. I'm not suggesting that will magically resolve the abortion debate, but one can reasonably expect that it will foster the kinds of conversations that should have taken place decades ago. Conversations about how a decent society should address all of the interests involved. And the European experience shows that it's easier than one might think to find approaches that are more respectful of women and less careless about the value of human lives that are not fully developed or that suffer from diminished capacity. We can be sure that the laws that will emerge will vary drastically, and they will not be satisfactory to everyone, but they will have a better chance to gain adherence than the Roe Casey regime. First, by giving citizens more in a say of setting the conditions under which they live, work, and raise their children. Second, by providing pregnant women and their families with more care and concrete assistance. And third, by excluding no one from the community for which we all bear a common responsibility. Thank you.
Thank you, Marianne. Professor Siegel?
Thank you. Thank you for the invitation to participate in the forum. I much admire the model of vigorous civil dialogue that you are pursuing through it. My comments are not going to be directly in response to Marianne's. I do have writing that engages with at least a number of the themes that she's put on the table, in particular to the genesis of the conflict in the abortion controversy, tracing it to different roots than the court's intervention. And I would be happy to talk about the logic of conflict issue, including the extent to which it's attributable to democratic processes rather than to adjudication when we get into the Q&A. But I'm going to go to my prepared introduction instead per plan. So right now, my thought is to just start off with my comments on stare decisis, which was not, in fact, the focus of my brief. And so my brief is, my comments will start on the stare decisis theme, and then towards the end, at least pick up a theme or two that's aligned more particularly with the brief that I co-authored. So Mississippi has a 15-week ban on abortion, which in our view is flatly unconstitutional under a half century of Supreme Court precedent. The law was passed to give the court that President Trump constructed by procedurally irregular means a vehicle to overturn Roe, and the court should refuse. The court should refuse because the court has already addressed the stare decisis question once in deep solemnity in Planned Parenthood versus Casey. And as recently as 2016, the court with Justice Kennedy voting resoundingly and robustly reaffirmed Roe and Casey. Quite literally nothing has changed except Trump's appointments to the court. Yesterday, in the midst of oral argument, Justice Sotomayor pointed out that the sponsors of Mississippi's 15-week ban and its up to 6 weeks ban each said, we're doing what we're doing because we have new justices on the Supreme Court. And she, Justice Sotomayor, asked, will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts? Those who seek Roe's reversal can talk of high constitutional principle, but as polling suggests, they're not the only ones looking at the court, and many Americans see otherwise. An appointments process culminating in Roe's reversal now would look actually worse than ordinary politics. Last night, the Washington Post editorial board used the phrase underhanded politics in talking about oral argument and the court's composition. I observe this to observe that many people are looking at the court right now, and it is happening in a sequence, and the sequence is visible to many people. 2, the court should refuse to reverse because the court already considered whether to overrule Roe, rejected every reason for doing so, and here I'm going to say something that's different than anything that was said in oral argument yesterday, already modified Roe's framework to take deep account of the very conflict that's now gripping the nation. The joint opinion was quite self-conscious about doing this. Even as it reaffirmed Roe, Casey modified Roe, jettisoning the trimester framework because, in the words of the joint opinion, it had undervalued the state's interest in protecting potential life. By substituting the undue burden standard for the trimester framework, the court sought to build a framework in which opponents of the abortion right could enlist their government in dissuading pregnant women who sought abortions, but could not obstruct the woman's efforts to end a pregnancy. The court designed the undue burden framework to channel the expression of two values, protecting potential life and respecting the dignity of women. As I once put it, the undue burden framework allows the government to regulate abortion in ways that respect the dignity of life, so long as the regulation respects the dignity of women. Casey's undue burden framework is not unworkable. It coordinates community interests in protecting potential life with constitutional protection for the pregnant person herself. Casey refashioned the Roe framework in such a way as to put advocates for each of these interests in a relationship where they would have to reckon with the constitutional claims espoused by the other. In so doing, the court explained that it was, quote, calling upon contending sides of a national controversy to end their national division by accepting a common mandate rooted in the Constitution, close quote. Casey replaced Roe's trimester framework and its rule-like clarity with a standard that allowed robust expression of pro-life views. Nearly all of the abortion restrictions upheld in the last 30 years would have been unconstitutional under Roe. Just think of that. For that accommodation, the pro-life community has repaid the court with a river of contempt, seeking nothing less than a constitution that reflects only its own values and worldview. Looking at the clock. Finally, I ever so briefly reached the merits. The court should refuse to overrule Roe Casey because the Constitution is not neutral when it comes to the question of women's liberty and equality. The 14th Amendment's guarantees extend to women even if women were denied the vote and voice in shaping of this nation's laws for hundreds of years of its history. I note that women were 1% of Article 1 judges when Roe was decided, represented in ones and zeros on the nation's law faculties. And as I've recently written with Doug Nugent, this goes a long way to explaining Ely's views on Roe, which can be distinguished from Lochner. So yes, liberty's at stake. Government coercing pregnancy violates bodily integrity and can threaten life and health. In the US is 55th in world maternal mortality in the world, last among nations of equal wealth. And this is before you focus on the force multiplier of racial disparities. And yes, government coercing pregnancy violates an individual's freedom to make decisions about intimate and family relationships and about the bearing and rearing of children. And coming to the root of things, as Justice Ginsburg explained, when government coerces motherhood, it violates the Constitution's equal protection guarantee. Society is all too quick to take authority from women and all too quick to assume that women owe a duty of care that society as a whole, it seems, does not. For me, the equality perspective means above all to analyze abortion laws in social structural perspective, expand the frame, stop looking at abortion as a single issue, and I have in ways too numerous to count. So briefly, and here's the last couple words, in this brief, which I submitted, an equal protection brief in Dobbs with Melissa Murray and Serena Mieri, we invited people to look at the way in which Mississippi focused its energies in protecting unborn life and in protecting women's health. As we showed, the state zeroed in on women resisting motherhood, referred to them as the maternal patient, while leaving wholly unaddressed any measures that would take non-coercively outside the abortion context to support all those sexually active who wanted to avoid pregnancy, and critically to support all those who wanted to bring healthy pregnancies to term and to raise healthy families, failing to spend literally millions of federal dollars available for those purposes. Even with the highest infant mortality rates in the nation, Mississippi refused to expand Medicaid and has the lowest TANF benefit levels in the nation. And this is my last line here. I believe it is in this expand the frame perspective, in considering questions of sex ed, contraception, healthcare, social provision, and in networks, both voluntarist and public, that we have the best hope for exploring and perhaps finding common ground between branches of pro-choice and pro-life movements who want to find common ground, who believe in a care ethic, and who believe in committing to and providing for life and for the next generation, as I do so very many people of goodwill in the pro-choice movement are concerned to. And I'll stop there.
Thank you. Thank you both, Marianne and Reva. Let me start with a couple of questions that I had before we move to some questions from the audience, and you should both feel free to answer them and just and have a back and forth. One, I think that is on a lot of people's minds after yesterday's oral argument is this question of super precedent and whether Roe is a super precedent, along with perhaps some other cases, including Brown versus Board of Education. And I think that one of the kind of pointed questions that came up yesterday was the question of whether there's a paradox here, that if there's a case that is so in part important because of how much it's been criticized and how much contention there has been around it, does that make the case more protected as precedent or less? I think that was a question that was on some people's minds. The fact that it is so criticized, does that go to whether the court should be very unwilling to overturn the case because it'll look like it's in response to public criticism, or should the court be taking into account just how contentious and unhappy some people have been about the case?
Well, I'd be glad to offer a few thoughts on that. There are lots of, to use Justice Breyer's word, there are lots of watershed cases, some of them that we prize and honor, and some of them that embarrass us. And I really don't think that the fact that a precedent is so highly visible, Justice Breyer mentioned Brown. Brown is a case where the court overruled a precedent that had excluded a whole group of human beings from important opportunities. I think the analogy to Brown-Plessy puts the current situation much more in the category with Brown as a case that remedied a long-standing injustice. As to whether the court should be influenced by the high level of controversy, I think that's the very problem that concerned Justice Breyer and many of the other justices about the current case. Clearly, the court's integrity, the court's reputation has been badly damaged over all the years, beginning with Roe. I would say it was Roe itself that damaged the integrity of the court, because the court, as practically every constitutional lawyer said at the time, in 1974, I was a visiting professor at Harvard Law School after Roe was decided, and all of the great famous constitutional lawyers of the day were very troubled by Roe's overreaching of judicial power. The other thing that has made Roe a consistent problem and that has damaged the integrity of the judiciary in minds of many is that Roe glossed over what is the single most difficult aspect, the most tragic aspect of the abortion question, the status of unborn human life. So clearly, the court should not be responding. It's too bad that it will always be responding now, or at least for a long time will be responding to public impressions, but it certainly shouldn't take that into account. What it should take into account is what Justice Breyer said is the basis of the integrity and the authority of the court, and that is its reasoning and its adherence to the Constitution and the public perception that the court depends on reasoning and that it adheres to the Constitution.
there's a long way to go here. First of all, I will start by saying that there's no doubt that there is strong and passionate feeling on both sides of this question. And I am prepared to recognize respectfully that there are people of strong goodwill on both sides of the question. I am not sure that that is reciprocally handled. And the way in which the Plessy analog is being handled in this conversation calls that into deep question. There are women who have asserted this right and women of color who have asserted this right over decades now. At the point at which Roe was decided, there were women who were dying under criminal abortion laws, and women of color in particular at risk, their lives and health at risk because of these laws. And I'm speaking with caution because I'm being careful about walking into this, what I view as very explosive racial space over the way in which this analogy is unfolding. And I haven't had enough time or space in taking in yesterday's argument before I really want to say more about, because I have respect for the views of those who've put the analogy on the table, and because I have deep, deep concerns about the way in which it's landing, and because we're in a public space and I haven't had time to think this through, I will just say, I don't think that the analogy is fully apt, and it's missing very, very deeply important dissimilarities. And I'm just pausing for all of us to take that in. And I'm just, because I'm concerned, I'm just going to pause right there. I am really, 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 really worried about this. The women in Mississippi who are at risk because of this law, both white and of color and poor, are doing their best and are not being provided the assistance they need, many of whom would choose otherwise if given the provision they deserve. And I look at the record there and I'm appalled. As a society, we can and should do better by them. And the way that this problem is structured is, it breaks my heart actually, and it puts me to shame. And the kinds of judgments that are being made here strike me as altogether wrong. Life is on both sides of the equation, and it ought to be addressed that way.
But you may want to get onto another question, Jeannie, but I think listening to Reva, it makes me realize that there are many points in what Reva said with which I would agree strongly. And one of them is that our states and our social institutions are not giving women the care and attention and support, concrete assistance that they need during and after pregnancy. And I think there's another point on which I would strongly agree, and is related to the first, and that is that abortion is not a single issue. I think one can't stress that enough. Abortion is an issue that involves women, families, children, and the interest of not just the state, but society, and what kind of a world we're bringing into being.
The way I understood the way the Plessy analog was being introduced into the oral argument, and there are many ways that one could discuss how they're disanalogous, but the one way in which it seemed to be operating in the oral argument was that it was so wrong. Plessy was so wrong. And there are people today who believe Roe is so wrong, and wrong at that level, And then so the question of stare decisis and whether the overturning becomes one where you use the Plessy analogy to say, well, given that it was so wrong, do we need to, what are the kinds of considerations that one needs to engage in terms of the stare decisis factors to say that it is worth overturning or that it is justified to overturn? And so I think that the degree of intensity of the feeling of wrongness is what I take away from the analogy. And I wonder if either of you would agree with that.
Can I just make some observations about the so wrongness? Right now, I've read several polls that report that 6 out of 10 Americans do not want Roe reversed. And I don't know how that squares with this so wrong. I also know that as of 5 years ago, there was a court that reaffirmed resoundingly, actually, women's health was a very strong reaffirmation of the KC framework. Okay, so I'm not sure then where this is getting its bite. And what I tried to say at the beginning of my remarks is, if there's a court that's so clear that KC is so wrongly decided, it appeared during the presidency of Donald Trump, accomplished first by Merrick Garland not having his nomination considered by the Senate during Obama's presidency, and then the sequence of events during the Trump presidency. And that state of affairs, that court coming to this conclusion makes this a strange sequence of events to reconsider a judgment as of 2016. That's what I'm talking about in terms of procedural irregularity. That's what Justice Sotomayor was referring to as stench, you know? That's called political will.
It strikes me, and perhaps you would disagree, either of you.
Or court packing.
That there's, whether it's court packing or political appointments, the appearance that you change justices and then you get a new constitutional ruling, all of those things are going to make our politics explosive. Perhaps they already are. And so I wanted to go back to Marianne's suggestion that our politics, being as contentious and as ugly as it has been over the last 50 years, is attributable to Roe. Whether or not you agree with that statement, aren't we just in that situation where there's no way out at this point? Whatever the court does, we're going to continue with this incredibly explosive, ugly politics focused on abortion. And so what role does this even play in terms of like what it's done to our politics in the past 50 years? You know, you can disagree or agree with that characterization, but it is, I think it's quite certain that regardless of what the court does now, we will have a politics that is very focused on the Supreme Court, on its personnel, appointments, and you know, electoral politics will be deeply influenced no matter what.
Can I tell you something? I had pointed out that I wasn't before going to respond to Marianne's open because I had prepared remarks on the stare decisis point. I have a paper that I wrote with Linda Greenhouse in 2011 called Before and After Roe v. Wade, New Questions About Backlash at 120 Yale Law Journal 2028. And this paper traces the rise of backlash. I can't reproduce the whole argument, but I'll say very briefly that it traces the distinctive polarization of US politics around the abortion issue, the fact that we're different than Europe, to American. Of course, there was conflict over abortion before Roe. We know there was. But the supercharging of politics after Roe was very, very much about party realignment. What do I mean that? I mean the use of the issue to recruit persons in the Democratic Party to the Republican Party. That is to say, it was rooted in Democratic Party politics. You want to have an illustration of this? At the time of Roe, what was the party of the president who appointed the members of the Roe court? They were Republican president-appointed justices. Now, the party of Roe is Democratic, not Republican. Republican is the party of opposing Roe. Okay, there's been a switch of parties because Reagan recruited conservative Catholics from the Democratic Party. And over 20 years, there was this shift. And we have a lot of evidence in this paper. People who are interested in looking at this hypothesis are welcome to look at the paper. I also have a lot of papers from, I went into the hearings of the Watergate committee and read Pat Buchanan's efforts to recruit people who might vote for Republicans in that period from the Democrats. And it's a very fascinating story of the political process working. You know, it's not like something suspect happened. It's politics. It's American politics at work. And it shows us that, yeah, the court played some role, but you know what? In Justice Stevens's hearings in 1975, there was not a single question asked about abortion. High polarization really happens in the years afterwards. It grows. So I'm just saying it's not so clear that the court caused everything. Mm-hmm. I'm just putting that out there. It could be our politics did it.
Yeah, Marianne, there's been a lot on the table. I want to give you a chance.
Yeah, I'm going to try to, there are a number of points that have been raised. One is very quickly on the 6 out of 10 Americans saying that they don't think Roe should be overruled. If you ask Americans on particular aspects of the Supreme Court's abortion regime, they will answer in a very different way. And that is because from day one, very few people have understood what Roe's companion case, Doe, did to the abortion regime with its broad definition of health, which is so little restrictive of abortion, health as well-being. It means it puts the United States in a class almost by itself with some other countries that we don't really admire in carelessness about the importance of unborn human life. But let me, a couple of other things that I think are really important that both of you raised.
And I agree with you. I agree with you. And I want to say, though, that I think that Casey made many of those compromises. And in that respect, Casey's more like the German case now. You know, that's, I want it. So, I mean, in the spirit of saying, finding places where we can agree with each other, I don't think that all Americans want categorical regimes, and we don't have them now, you know.
Right. So that brings us to what is nevertheless egregiously wrong, getting to your question, Jeannie, egregiously wrong about Roe and Casey. And I think that one of the best indicators that they are egregiously wrong is that the court itself has been continuously disappointed with its own reasoning. When the Casey plurality affirmed Roe, it wasn't because the justices said that Roe was correct as a matter of constitutional law. In other words, they did not say that the abortion right was grounded in constitutional text, history, tradition, structure. Rather, it was on the basis mainly of stare decisis, which in turn was based on an unsupported assumption that it would disrupt women's reliance interests in the right to abortion. And secondly, in concern about, as Breyer emphasized, it seems to be most important to him now, the integrity of the court. The problem with the reliance interests, it seems to me, is there's simply no way for the court to determine how reliance by some women on the right to abortion compares with the number of women who have been harmed by the right to abortion, or the men who have relied on abortion, women harmed by being pressured into aborting a wanted child or being left alone to deal with an unwanted pregnancy. So Roe is not tethered to the Roe and Casey are not tethered to the Constitution. They've never been able to be convincingly tethered to the Constitution. And that, together with the studied glossing over of the intentional taking of a human life, is what makes Roe so continually indigestible in the legal system. Now, Jeannie's question is a very important one. Well, no matter what the court does, haven't we ruined this issue to the point where nothing anybody does can ever restore the integrity of the court or settle the controversy? Well, it seems to me that I have more confidence in the American democratic processes. I think when Casey and Roe empowered the strident voices in the debate, but if the debate is returned closer to the people who are actually affected by all the interest involved, I think we will see, as the European experience shows us, it is much easier than one may think to find legislation that is more responsive to the needs and desires of everybody concerned, and that while it will never completely quell the controversy, it will be something that we can live with.
I would like to say something to Marianne, if that's okay. When you say that the court just was giving way to stare decisis, I would like to say, as someone who doesn't share Justice Kennedy's views and who viewed him really from the outside, but I mean, I came up in a world where he shaped my horizon for a very long time. And I made a study of the man as someone who shaped my horizon. I think he had a view that he was responsible somehow to try to shape a world in which warring factions could somehow cohabit. And he had somehow or other dimly, he had some view that we were a polarized set of tribes. And there was some way that the court, whether it was race or guns or whatever, that the court had some responsibility to keep it all stuck together some way. He plainly did not feel comfortable ever with the abortion issue. But as a libertarian, he found a way to find his way to some place in the question. And other of the areas where he found his bearings uncomfortably, he also did same. And I guess I just want to say that I don't think it was just like a pig's ear. I think he felt some way to make a constitution that was a constitution that Americans could find themselves reflected in. And so when you say we can just go back, we can be Europe, we can be whatever, I'm not thinking that's going to be so easy. And my remarks were trying to say that I'm not expecting to find a constitution that's just going to look like me and mine. And I don't know that it's a reasonable expectation. And I think we've got to find a world where we can try to find a way to be in it with people with whom we disagree. And that's the kind of constitution we're going to have. And that's not just stare decisis, that's about finding out how we're going to live in a world where we're not going to agree, Well,
I guess what I'd say about that is the role of the judge. The judge takes an oath to decide without respect to persons according to the laws and Constitution of the United States. Doesn't say anything there about making a constitution according to the idea of the judge about what people will agree upon. I think that is left to the elected branches of the government.
Oh, yes, and here I'll just go back to where I started, and I know that Jeannie wants to move on. And here is something I feel just passionately about. When you say text, history, and structure, according to whom? Excuse me, according to whom? You're a very patient woman, I have to say, as you were at the Harvard Law School with how many other women? According to whom? Really? I mean, really, it's true we wouldn't decide the case the same way, but really, liberty, equality, what do those terms mean? And Justice Kennedy understood it to be comprehensive enough to speak to this question. And that's exactly what's at stake here. It's totally what's at stake here. I mean, I have a paper which I did on the occasion of the 19th Amendment about the democratization of the family. And I know you and I won't see it through the same eyes, but you can find women, you can find Lucy Stone talking about questions of voluntary motherhood, a woman's ability to say yes to consent to sex in marriage, to say yes to motherhood, as being fundamental all the way back before the ratification of the 14th Amendment. And why isn't that fundamental to our understanding of liberty? Why is it not in the first instance? I mean, these are the people who actually led the petitioning for the 13th Amendment, who tried to be part of the fashioning of the 14th Amendment. Why is this history not our constitutional history? Really now, there's no good reason, especially when Clarence Thomas quotes Frederick Douglass, there is no reason that these voices are not our voices,
So one of the things following on this exchange and combining some of the questions that have come in from the audience, I'm going to do a two-pronged question and comment. One is that some people have noticed, and that even taking the phrase, Marianne, that you use, the intentional destruction of human life, obviously that is a belief that many people in this debate have, that there is a human life that is being destroyed. And others take issue with the idea that there's a human life there. And that goes kind of to the centrality of these metaphysical views about when life begins. There's the role of religion and theocratic views that some members of the audience are concerned about and want to know your views on whether there's a place for these kinds of religiously inflected views, and to the extent that we have secular philosophies and religious views about when life begins, where does all that fit in to the discussion of these constitutional issues? And then second, in the European model, the European approach, one of our audience members suggests that it is much more generous to both women and to the unborn. And that, for example, in Germany, the fetus is considered a person from the moment of conception and is protected under the basic law. Yet at the same time, the government still subsidizes abortion for women who are too poor to afford one. But in the US, on the other hand, we have some states that prohibit abortion that don't show concern for human life right at conception. And they also fail to provide pregnant women with assistance. So it is, and this I think basically goes to what would returning this issue to the states really look like in the way of leading to less polarization and more political compromise, because it seems to be that perhaps US society is very different from European society on these issues, as they are on other issues such as guns and healthcare and hate speech, and there's a whole gamut. Abortion is not the only one. And we seem to come out differently every time on some of these contentious issues. Oh, you're muted, Marianne, could you unmute?
I think these questions are mainly directed to me, so I'll offer some thoughts on all of them. The idea that this involves a belief or a philosophy or religion that human life is present from conception, I think that's just the short answer to that is it's a scientific belief, which is that everything that is present in you was present at the time of your conception. And I think Roe, I mean, maybe one could say one of the big changes, if one asks what has changed since Roe, is that the scientific basis is so clear now that religion and philosophy and belief just doesn't come into it. The question is, what do you do about it? And the German solution that the questioner raises, this is an example of how one country tries to give adequate attention to all of the interests involved. And that involves a kind of democratic compromise, a political compromise that I would agree is much more attentive to the actual needs and care that people require, women require when they're in a situation dealing with an unwanted pregnancy. And I think one point on which Reva and I would agree is that, and I'll say this as a comparatist, that the United States is much less, has much less attention to the needs of pregnant women, of children, of child-raising families than most European countries do. And then finally, does this just go on forever? Is the United States really different in this respect? I don't think so. I think what will happen when the abortion issue is returned to the states, that you will hear more voices about precisely what we should be doing for child-raising families, for women and children. These voices have not been heard, but when legislatures actually have the responsibility for dealing with this problem, rather than just passing laws to try to get Roe and Casey overruled, I think you will find that the debate will not line the pro-choice or pro-life people up exactly with the positions of the two political parties. And I view that as a very positive and hopeful prospect.
Can I just ask a question? I have never understood why it's an if-then. That is to say, why it is that I keep hearing this, that when Roe is overturned, then people think about social supports. Why wouldn't it be the other way around? Like no paid leave, no Medicaid expansion, and let's expose people to compelled motherhood when there's the highest maternal mortality rates across, Western countries. It doesn't make any sense to me. And I listened to Justice Barrett talking about, we don't need to talk about motherhood because women, you can just have liability waivers so that women can just abandon their kids and not be criminally sued for and criminally punished for a child abandonment. It's like this neoliberal story about you're just going to criminalize abortion and someday we'll have a social safety net. But it's backwards. I guess that's what I want to say. It's totally backwards.
Well, I'll just respond to that by saying that I believe that full debate of the abortion issue has been stifled by the judicially imposed abortion on demand regime. And I have confidence that the voices that will emerge and become stronger in real debates about case state by state, of course, the federal government may get involved, but we could talk about that. But I have full confidence in the fact that each state will have a fuller debate, fuller participation, and this may bring laws that will be uncomfortable for both political parties.
Believing the court's too much power.
Is this truly a kind of a zero sum where where there is no judicial resolution from the Supreme Court that could satisfy both of you? Marianne, you're muted.
The court has intruded into an area of public policy where it had no business being in the first place.
Well, following up on Reva's idea that Casey itself undertook, in fact, to not only balance the interests but also to leave room for democratic expressions. That, I mean, is something right now, it is, but those of us who listen to the oral argument, I think many people are saying it's either going to be an overturning of Roe, or maybe there's a chance that there's some kind of compromise that could be reached, unlikely, but maybe that the Mississippi law is upheld, but that somehow Roe is kept in place in some form. And Marianne, for you, is that a complete bust?
Well, if I were in Las Vegas, I think that will be a very tempting avenue for the court to take. It'll be the most politically expedient avenue for the court to take. But I don't think it will solve the problem of the legitimacy of the courts being in the area.
And Reva, would you like to have the last word?
Reproductive rights or voting rights? Voting rights, voting rights.
Thank you.
Okay.
I think we're done. I think we've now at the end of our time. Thank you so much to both Marianne and Reva for this bracing conversation, and for the audience for joining us and for your questions, which I tried to combine. And but there are, of course, many, many remaining questions. And hopefully we will continue to have these discussions, including in the various listening circles that will be happening at Harvard Law School tomorrow.
And Jeannie, thank you. Thank you.
Thank you,
very much.
Jeannie.
Thank you.